welcome to Consumer Counterpoint. I'm Christine Argentine, a partner at Cypher Shaw. This is your video cast that talks about consumer issues mostly affecting litigation, class actions, things that we're seeing, trends that we're seeing in that type of space.
And I'm Paul Ivanek, a senior associate in the Chicago office of Cypher Shaw. And today we're going to be talking about Texas's mini TCPA statute. But I think, Christine, it might make sense just to kind of talk broadly about the federal TCPA, and so we can see kind of the similarities, the differences, and maybe some recent changes.
Yeah, so the TCPA was enacted in 1991, so it's been around for a really long time. Its purpose is essentially to regulate companies that are making marketing text messages, phone calls to consumers, and to regulate the use of that in terms of, are they using auto dialers? Are they using pre-recorded messages, artificial voices? And then generally, if you're marketing via text message, you want to make sure that that text message isn't unsolicited. So there's a lot of rules around that. We've seen a lot of litigation in the TCPA over the years. Lately, it's been related to quiet hours, opt-outs, right? Are you honoring when someone says they don't want to receive that marketing call or message anymore? Are people on the national do not call list such that they're saying, they don't want to receive those messages? So we've seen lots of litigation, lots of class actions over the years under the TCPA. And of course, as is common, right, a lot of states have their own telemarketing laws, and that's kind of what we're here to talk about today.
Right, but I think also, we saw TCPA litigation kind of ride this roller coaster. It seemed like there was a lot, and then it really slowed down mid 2010s, and then we're seeing it pick back up again. Can you explain maybe why we've seen a little bit of that?
Yeah, I think a lot of it has to do with case law development, some really significant Supreme Court decisions, kind of narrowing some of the definitions under the TCPA. And then over the years, right, so that kind of where we saw an uptick and then we saw it come down. Over the years, the plaintiffs have gotten a lot more creative. And there's a lot more marketing going on, right? Companies want to market via SMS. Companies want to get their name out there. And so as we see an increase in this type of marketing, of course, we see another increase in the litigation.
Sure. And that makes sense with the creativity. Okay, so Texas mini TCPA, as you said, Christine, a lot of states have mini TCPA statutes. So Texas, is this something new? Is it something that's been on the books for a while? Or?
Yeah, so almost all statutes have some sort of telemarketing, telephone solicitation laws. Texas is no different. They've had a law for about 15 years regulating telephone solicitations, telemarketing. And you see a lot of these state statutes kind of mirror the TCPA in many ways, right? Especially with respect to the same categories. So Texas has always had certain quiet hours in place, right? So under the Texas laws, the quiet hours, you can't make phone calls Monday through Saturday before 9 a.m. or after 9 p.m., right? So those kind of overnight hours, you shouldn't be marketing to people via
Sure.
Telephone calls or text messages. And then on Sundays, it's 12 p.m. to 9 p.m. So Texas is a little bit stricter than the TCPA, especially with respect to Sundays. But those hours have always existed in their telemarketing laws. Additionally, right, Texas has always had its own do not call list, right? Okay. So as everyone knows, you can kind of sign up on a national do not call list, but particular states have their own do not call list as well, and they kind of say sign up on ours and we'll combine with the national, and then that is the list of people that marketers or companies can't market to if they're on those lists, absent some sort of exception.
So when we're counseling clients kind of on that issue of registering state and federal, are we having them register on both? Are we having them just go through the state and hoping that the state just combines with federal? What does that look like?
Yeah, what's interesting is that for a lot of states, if you register your company with the national do not call list, you basically get flagged for the state, and the state kind of will reach out to you and say, hey, I see you registered for the national.
Okay.
If you are soliciting to people in our state, you also have to register with us. Most states have registration requirements if you fit within their definition of a telemarketer or a telephone solicitor.
Okay. And so we, obviously TCPA has that private right of action. It's the same thing in Texas. I know some privacy statutes don't in Texas, but some do. So what does it look like there?
Yeah, so the old statute, before these recent amendments that went into effect September 1st, there was a private right of action there, but there were some procedural hurdles before you could pursue that private right of action, right? You had to submit the violation to the state, some sort of state agency, the AG, and then if they didn't pursue it, you could pursue it. That has changed. But the registration requirements have always been there. And I think it's important to note about the registration is that there are lots of exemptions in Texas, particularly under the registration. One being if you're registered with the SEC, you're a publicly traded company. So, there are ways in Texas so that you wouldn't have to register as a telephone solicitor, which is important because it costs money, right? And
Sure.
it's a $5,000 violation if you're supposed to register and you don't.
Okay.
So companies want to kind of look really closely at those registration requirements to see if they need to and to make sure that they are registering. It's a pretty onerous requirement, right? You have to submit a lot of information
Okay.
with the registration, and that's true for a lot of states.
Okay. And so, so there's the hurdles, there's, so are there statutory violations besides the $5,000 for not registering, but what about for violating the statute?
Yeah, so under Texas laws, it is $500 per violation. It's very similar to the TCPA, right? So if you're bringing that private right of action, you can pursue those particular damages.
Can you pursue them in addition to federal TCPA, or
Actually, in Texas, you can.
Okay.
There was always some case law out there that said you could kind of pursue those side by side. But again, that is another change that has recently been made. And then I think what's important about the Texas statute that has always been there is that it's always had this broad definition of an automatic telephone dialing system. So we saw the Supreme Court narrow the definition under the TCPA several years back now, which kind of truncated that type of litigation. Texas has a broader statute. Okay. So whereas the TCPA talks about this kind of random number generator, this sequential number generator as applying to, storing and producing numbers, right? That's how it redefined the TCPA. Texas still has that or language, right? So Texas's statute still says any equipment that can store telephone numbers or
Right.
produce numbers using a random generator, number generator. So there's a bit of a question there that hasn't really been litigated a ton about what that means and whether that is consistent with the Supreme Court's decision or whether that's a separate, broader definition.
So with those differences, are we seeing a lot of TCPA and Texas mini TCPA claims brought under the same action?
We haven't seen a ton of it yet.
Okay.
However, with these new amendments, I think we're going to see a lot more.
Okay.
And I think that's probably because of the procedural hurdles that now no longer exist.
Right.
So let's talk about the new amendments that went
Sure.
into effect on September 1st. So one thing that is relevant to what we're talking about here is that there is now a private right of action under the statute that is pursuant to the Deceptive Trade Practices Act. So essentially the statute now says if you have a violation of this statute, you have a deceptive trade practice.
Okay.
So they're creating a private right of action there that didn't exist before and making it easier to bring basically a violation case, a case alleging a violation in Texas.
Okay. And so what other amendments have we been seeing as well?
So another amendment is that now the Texas statute expressly applies to text messages. Many states that have telemarketing laws talk about telemarketing in terms of phone calls,
Yeah.
right? Which, again, it is given the timing when a lot of these statutes went into place, that makes a lot of sense, right? That was the marketing calls that people didn't want to get, right? Now states have been expressly expanding their statutes to text messages, because
Okay.
that is now, right, the most common marketing, or a very common marketing that you're getting.
Also, probably to avoid the argument, well, this is a text message and not the phone call.
That's right. And so, under the TCPA, right, the FCC has said text messages are the same as calls. But so now Texas statute has expressly stated a telephone solicitation includes calls and texts and graphics, right? So it's expanded that definition pretty broadly.
Okay.
And then another amendment that has been made is that it kind of added language, which we talked about earlier, about how you could kind of double dip under TCPA in Texas.
Right.
It added some language essentially expressly allowing that, right? Saying, you can collect for the same violation multiple times, right? So now you've got Deceptive Trade Practices Act, right? A violation there, which could result in, actual damages. You've got the $500 violation, right? That's under the Texas statute. You've got TCPA. So you've got a whole bunch of opportunities to take one violation and kind of multiply those damages a couple times.
Yeah, and we have, obviously, with the amendments, we haven't seen how the courts would treat that, down the road, of whether or not that is such an annihilative liability type, approach of multiple statutes for the same conduct.
Yeah, I mean, and I think, we've argued in different states that you can't double dip, but that's always been a hard argument in Texas. But now that argument is pretty much gone, right? You can't make that argument anymore with these new requirements, And then I think, so one thing that I think companies want to pay particular attention to. I mean, of course, this statute was already there. It already required you to honor an opt out, to scrub against the DNC. But now with this private right of action and with these amendments, I think there's going to be a lot more focus on being able to bring a claim there, and we're going to see a lot more litigation. And so we want to make sure everyone's tightening up their practices, right, and making sure that what they're doing in Texas, especially text messaging, is compliant with what already existed under the statute and the new amendments.
Yeah, so that was actually going to be my next question is, so we advise with TCPA at the federal level, we're mindful of the many TCPAs at the state level. Is there anything that, in addition to what we're advising on the federal TCPA, that we should maybe be doing with like many TCPAs like Texas, especially given the amendments?
Yeah, I mean, I think unfortunately it's a patchwork of across the states, right? Sure. And so of course you want to be compliant with the federal laws, and that's where we're seeing a lot of litigation. That's where we're seeing national classes being pursued, so the exposure there is very high. But with these states that, like Texas, that have a private right of action, we need to be mindful of where those requirements are stricter.
Like the quiet hours.
That's
and
right.
Stuff. It's just expanding the quiet hours. So if you're good in federal TCPA, doesn't mean that you're always just good at the mini level, with Texas.
That's right. And so it becomes very challenging for businesses, especially national businesses, to figure out, right, what are the parameters they're going to put around their marketing to kind of accommodate all states, right, and all the state statutes versus, trying to figure out what they can do in each state, right? And usually when you're talking about national marketing campaigns, it's not really an option. So it's important to kind of look at what states you're marketing into, right? Mm-hmm. Whose residents you're contacting and you're targeting, and take a look at those mini statutes, those telemarketing statutes, to see what requirements you need to comply with.
Yeah, and I think from a litigation perspective, it seems obviously that the amendments went into place September 1st. We're probably not going to see a whole lot of interpretation by the courts, especially appellate courts, until 2026, I'm assuming.
That's right. And I think there's other states doing similar things, sure, right? So Oregon had just passed a new amendments to their telemarketing laws. Those are going to go into effect January 2026, so we'll talk about those at some point. on this vidcast about what those changes are
Right.
and what compliance. But I think we're going to see this more and more, right? I think we're going to see states amending their statutes to come in line with kind of the realities of marketing these days and what consumers are complaining about, right? It's not so much calls to their landlines anymore, because I'm not sure how many people have landlines anymore, right? Now we're talking about cell phones and text messages. So I think we'll see a lot more amendments come out.
Yeah, kind of this, new technology, new approaches and new interpretations of the law, and amendments. So
Yeah.
that all makes sense. And so I think, obviously we'll keep people updated here on
We
the
will.
Texas mini TCPA, talk about Oregon at some point as well. We'll have probably a full-blown episode on the federal TCPA.
Yeah.
So,
Yep.
great.
So join us next time. But yeah, we'll keep talking about all the trends we're seeing.
Absolutely.